Next point I am going to explain is about offer. An offer is different from an invitation to receive offers. An offer is the final expression of willingness of by the offerer to be bound by his offers should the party to accept it. The offerer should manifest readiness to enter into an agreement to such a degree that the only thing to be awaited for is the assent of the other party. Where a party without such manifestation proposes certain items on which he is willing to negotiate, he does not make an offer but only invites the other party to make an offer on whose terms. Perhaps the basic and vital difference between offer and invitation is to receive offers. For making a valid contract, there must be a lawful offer and lawful acceptance of that offer. An offer is also called a proposal. The word proposal and offer are synonymous and are used interchangeably. Section 2, subsection A defines the term proposal as follows. When one person signifies to other his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make an proposal. From the above definition of offer, you will notice that an offer involves the following elements. It must be an expression of readiness or willingness to do or to abstain from doing something. Thus, it may involve a positive or a negative act. For example, an offer to sell his book to B for rupees 30. A is making a proposal to do something, that is to sell his book. It is a positive act on the part of the proposer. A, on the other hand, when A offers not to file a suit against B if the latter pays A the outstanding amount of rupees 1000, the act of A is a negative one. That is, he is offering to abstain from filing a suit. So it must be made to another person. There can be no proposal by a person to himself. It must be made with a view to obtain the assent of the other person to such act or abstinence. Thus, a mere statement of intention, I may sell my furniture if I get a good price, is not a proposal. The person making the offer is called offerer or the promiser, and the person to whom it is made is called offeree. When the offeree accepts the offer, he is called the acceptor or the promisee. For example, Ram offers to sell his scooter to Prem for rupees 1000. This is an offer by Ram. He is the offerer or the promiser. Prem, to whom the offer has been made, is the offeree, and if he agrees to buy the scooter for rupees 1000, he becomes the acceptor or the promiser. See, this is called as offer. And next one is the essentials of a valid offer. An offerer expresses his willingness to abstain or from doing with a view to accent the offer. Intention to create a legal relation. A valid offer could be expressed in for expressed form, that is in words either written or spoken or implied form or by contact. The terms of the offer must be certain and not ambiguous. The offer must be clearly communicated to the other party. When the proposal is accepted by the offerer, it results to an agreement. Acceptance is the assent given to the proposer. And next one is the conditions of a valid acceptance. The acceptance must be absolute and unqualified. That is, acceptance must be absolute. There should not be any condition attached to acceptance. Acceptance must be communicated. Acceptance must be communicated to the offeree in the manner prescribed. A mental acceptance to an offer is not a valid acceptance. Acceptance must come to the knowledge of the offerer. Acceptance must be communicated within a reasonable time. It is, acceptance must be communicated within a reasonable time prescribed. If no prescribed time is there, it must be given within a reasonable time. Then essential elements of a valid contract are offer and acceptance. First one is offer and acceptance, legal relationship, consensus, ad idem. Offer and acceptance is already discussed. Legal relationship means the parties to a contract must have a legal relationship. Consensus ad idem. That is, the parties to an agreement must have a mutual consent. That is, they must agree the same thing and in the same sense. This means that there must be consensus ad idem, that is identity of mind, meeting of two minds. These are the main essentials of a valid contract.